everyone again. This is Natalia. I'm an immigration attorney with McEntee Law Group. We're a law firm here in Chicago. We practice immigration law only, so we represent clients in business immigration processes, in family immigration cases, and also in removal proceedings. We do that here in the US and we do it outside of the US, handle the processes called consular processing outside of the United States. Very good to see you all here. So we have a webinar which is an overview of the naturalization process in the United States. And to tell you a little bit about myself, I am Natalia Blauvelt, an immigration attorney with McEntee Law Group. I am mostly practicing naturalization, family-based petitions, and removal defense in immigration court. All right, so September is a month which we in AILA, in the American Immigration Lawyers Association, celebrate in Naturalization Day, Citizenship Day here in the US. So we decided to hold this webinar in September as well. And I see that we have some people joined here, so we are going to start. All right, so this webinar is for informational use only. This is not a legal advice. Even though I am an attorney, I'm not your attorney. So you have a very specific case. I'm sure if you would like to apply for naturalization, my general advice is to seek legal consult with a licensed US immigration attorney so that all aspects of your case can be reviewed and you can receive the best legal advice specific to your case. All right, let's start. So we're going to talk about the process of becoming a US citizen, which is called naturalization. Just to make sure, I want to clarify that this process is for someone who has a green card. Usually a person who is applying for naturalization does not have US citizen parent or parents. And if that's your case, you have a US citizen parent or both of your parents are US citizens, either born in the US or naturalized, then you should consult with an immigration attorney to see if an N600 application would be a better choice for you, the right choice for you, because N400 is for someone who would like to naturalize, not for someone who would like to receive a certificate of citizenship. So there's a big difference between the two, and the certificate for citizenship form N600 should be filed for someone who is already a US citizen based on the Nationality and Immigration Act provisions and likely citizenship of the parents. So please keep that in mind. This webinar is not going to cover the N600 procedure, which is a completely different case, has a different filing fee and a different review procedure. All right, let's talk about the basic eligibility requirements for naturalization. A person who would like to file for naturalization has to be at least 18 years old, has to meet the physical presence requirement, which is different from continuous residency requirement, which is another requirement for naturalization, has to establish that he or she is a person of a good moral character, and we'll talk about it during this webinar, what can help you establish that you're a person of good moral character and what happens if you have some red flags on your application or in your immigration history. An applicant for naturalization should also pass the US history and government exam and should demonstrate the basic level of English language. So these two requirements, the last ones that I mentioned, they come in play at the interview. So when you show up for an interview of the USCIS on the N400 application for naturalization, then you'll be tested on the US history and government structure, and you will also have a chance to pass the English language test, which is done, as writing, reading, and speaking. So that these two requirements do not come into play before you show up for the interview with the USCIS, and the USCIS would never waive an interview for a naturalization application that you file with the USCIS. The interviews are absolutely mandatory. An attorney may be present at the interview. It's an individual interview unless it's scheduled simultaneously for Form I-751 and Form N-400. Then we would recommend that your spouse comes to the interview. If it's just an N-400 interview, then that's an interview specifically for the person who filed the application, not for a U.S. citizen spouse if your green card was based on the marriage to a U.S. citizen spouse. All right, let's talk about all the requirements separately. So the physical presence requirement, that's the very first requirement outlined in the Nationality and Immigration Act. And you basically need to prove that you resided continuously in the United States for 5 years before applying for naturalization. That's a very general rule. There is an exception to this rule, which I will talk about later, but if you're applying based on this general rule, then you need to prove that you were present on the US soil for that you resided continuously in the United States for 5 years before applying. So you need to distinguish this continuous residency from the actual presence in the United States. So to prove continuous residency for 5 years, you would need to make sure you file your tax returns, you treat the US as your home, as the country where you have the most, your ties to that country compared to any other country in the world. You may potentially live in 2 countries at the same time, but the US should be your home where you should spend most of your time. So then we move to the physical presence requirement, which is basically to establish that you were physically present in the United States. So that means you should be on the US soil for at least 30 months out of 5 years. That's for those people who apply based on the 5 years of being a US permanent resident, and that's a general application for citizenship. Most of people file based on 5 years. If you are filing for a naturalization and you've been married to a US citizen and been living with the US citizen for at least 3 years before applying for a naturalization as a lawful permanent resident, then the requirements will be slightly different. So you would need to show that you resided continuously in the United States for 3 years with a qualified US citizen spouse. And it's important to note that you don't have to be married to the US citizen spouse who filed an application, helped you file an application for a green card in the past. It's just the requirement just states that it should be a US citizen spouse with whom you lived continuously, resided continuously in the US for 3 years as a married couple before applying for a naturalization. So if that's the basis of your application, so that's the very first step to determine the basis of your application. So if this is the basis of your application, then you need to prove that you were physically present in the US for at least 18 months out of 3-year period. So that's different from applying based on a general provision, which is 5 years. And applying based on 3 years, of course, involves more documentation to prove that you still reside with a US citizen spouse versus applying based on 5 years. Just keep that in mind. So here you basically are proving that you were a US citizen, you were physically present that you were married to a US citizen, that you were physically present in the United States for at least 18 months out of 3-year period, that you were residing continuously in the United States for at least 3 years with a qualified US citizen spouse. And you should, on top of that, you should also prove that your relationship are real. with the US citizen spouse. So you would need to provide some additional paperwork to establish to the US CIS that you are married, that you are living together. So any utility bills that you can provide, I would include them. If you have children together, that's a great proof of your relationship. If you file tax returns, then obviously they should be filed as married, separately or jointly. But when we're talking about tax returns, generally we would include it in every filing, even based on 5 years, but it's especially important for the 3-year basis of the filing for N400 process in the United States. There is no list of documents, like that should absolutely be provided to the USCIS. Every case is different, and if you have some evidence of joint finances, that's fine. You may not have evidence of joint experiences. You may have evidence of joint residency, but not joint finances. So every case is different. So make sure to discuss your case with your immigration attorney and have an attorney review the documents. So what are the benefits of becoming a US citizen? So first, it's a benefit of voting and being active in the community. As a US citizen, you can vote in the US state, local, federal elections, and that's a great benefit to have to influence the political process in the US. Another benefit is that by being a US citizen, you would allow yourself to travel and internationally to many countries without having a visa. You will be allowed to reside freely outside of the United States. You won't have to stay in the US for a certain period of time, like there is this requirement for lawful permanent residents, but there is no such requirement for the US citizens. There will be a wider range of employment opportunities because some of the jobs in the US, especially federal jobs that involve, security clearance, those sometimes require US citizenship. So that's a great benefit to have. Being a US citizen, you cannot be placed in deportation proceedings, so you can avoid deportation. As a permanent resident, it's possible that the Department of Homeland Security, may place you in removal proceedings if there are any, basis for being placed in removal proceedings as a foreign national, even if you have a green card. So being a US citizen will shield you from that. As a US citizen, you can also petition for certain family members to reside in the United States with you. So you can petition for your spouse, for a national spouse, based on a marriage petition. You can petition for your children under 21, and you can petition for your parents and bring them to the United States to live with you. So that's a great benefit to actually have your family in the United States. So whenever we discuss an application for naturalization, obviously we have this question, are you a good candidate for naturalization? So here we outlined, some issues that may be brought up during the interview process or during the adjudication process of the N400 application. Obviously, we want to discuss all of this at the time of the consultation or, as we are preparing the case. So what can be the potential issues, that we absolutely have to consider before applying for naturalization? So first of all, if you have children, minor children, then please make sure that you do not owe any child support. So there is no outstanding order or amounts that you have to pay for child support. If you failed to file taxes in the US or you still owe some taxes in the US, then make sure before applying for naturalization or even, before going to the interview with the USCIS, make sure that you file your tax returns. If you failed to file a tax return in the past, you can file. I'm not a tax accountant, so please consult with a CPA, but usually people are able to file an amended tax return or a tax return that is filed late with some penalties attached to it. If people owe taxes, we recommend that all the taxes are paid, or at least that you have a payment plan in place with the IRS that would allow you to pay your outstanding taxes during a certain period of time. Sometimes when people owe taxes, especially federal taxes, to the US government, we submit the payment plan from the IRS. We also sometimes submit a letter from an accountant if that can explain why the taxes are owed and what's going on with the tax liability here in the United States. It's also very case specific, and this is something to discuss with both your accountant and your immigration attorney. All right, so another issue that may come up and absolutely should be discussed is a false claim to US citizenship. So this is a very complex topic. Foreign nationals are not allowed to declare state anywhere that they are US citizens. And this is a very serious violation that is not taken lightly by the USCIS. So if you ever claimed to be a US citizen on forms I-9 or any other forms, even not related to employment, or if you registered to vote and stated that you are a US citizen, even if somebody else did that for you, but you signed the paper or you voted in the US, then it's a very serious issue. And before applying for naturalization, you should definitely talk to an immigration attorney. There are some exceptions from this, accusation of false claims to US citizenship, which we can also, discuss during a consultation if those are the issues, if this is an issue that a person has. But please keep in mind, this is very serious, and sometimes we would even ask a person to go and look for all forms I-9 to make sure that the person has never stated that he or she was a US citizen. For those males who lived in the United States during a certain period of time, there may be a requirement to register for a selective service. So the selective service is a requirement that exists in the US, and that there's a question on form N400 application about the selective service. It only applies for males who lived in the United States during a certain time. So if you're applying for naturalization and you're a male, your age is important for us to know, to advise you correctly how you can go around, the fact that you did not register for the selective service. Your immigration status in the US also matters. If, certain immigration status if you're in a certain immigration status and in a certain age group, you could be required to register for selective service versus if you were in a different immigration status. So if you're a male who lived in the United States between the age of 18 and 26, please be very careful with this question on the N400 application. And if that's something concerning, then make sure you discuss that with an immigration attorney. Also, when you apply for a naturalization, you 100% have a green card. So if you have a green card, then there is a requirement for you as a lawful permanent resident to spend at least 6 months in the United States within a given year. So trips outside the US for over 6 months are not desirable for lawful permanent resident. So if you had trips outside of the United States for over 6 months, or if you had multiple trips that in total were over 6 months within a given year, then that may be concerning. If you were outside of the United States for a whole year, then that's even a greater concern to talk about. So if a permanent resident of the United States spent over 6 months outside of the United States and then wants to come back to the United States using the green card, at the border, the CBP officers will immediately start asking more questions, likely than not. We see it in 90% of the cases. What was the reason for you to spend so much time outside of the United States? How often did you travel? They will look at your travel history in their computers. They will look at your belongings, more than likely what you have with you. They may place you in the secondary inspection, ask additional questions, call for a supervisor. Things like that may happen if you travel outside of the US for over 6 months within a given year, being a lawful permanent resident of the United States. If you spend more than a year outside of the United States continuously, then that breaks continuous residency requirement, which is one of the requirements for the naturalization process. So spending a lot of time outside of the United States is definitely one of the potential issues that you should consider before applying for naturalization in the United States. So another requirement that we have for the naturalization process is for the applicant to reside within the USCIS's district for at least 90 days. That's a local residency requirement. So let's say if you plan to move outside the district, as an example, outside of the state of Illinois, let's say to the state of California, then I would say spend at least 90 days before you apply for naturalization in the state of Illinois, because if you move to the state of California and decide to apply for naturalization out of there, then you would need, according to this requirement, spend 90 days residing in the state of California before you actually file for naturalization. For the Californian office of the USCIS, the specific office assigned to your matter, to be able to have the jurisdiction over your case. So that's a jurisdictional question, and that's one of the requirements. So that's not a physical presence requirement, keep that in mind. You don't have to be physically put in place for 90 days, in a certain area before you apply. It's a residency requirement, so you have to maintain your place of residence in the United States, in that specific area, for 90 days before you file in that specific district. All right, so let's talk about the steps involved in the process. So first of all, you need obviously to gather all the documents. Then once the documents are gathered, you may start completing Form N-400. And keep in mind that the USCIS sometimes updates the form, and you should always keep track of the edition of the form that the USCIS is using at a given day. And by that, I mean the day when you file your application, you should be using exactly the edition of the form that the USCIS is using at the moment. You can double check on that on the USCIS's webpage for N-400 applications. They update it regularly, and sometimes, whenever the form is updated, it may have additional questions, it may have additional options for you, it may have, different number of pages. It may look very similar, but something would be changed within the form. So it's always important to keep in mind that the edition of the form is extremely important, as well as the filing fee. On April 1st of 2021, we had most of the filing fees go up for most of the applications and petitions within the United States. So before, the filing fee was $725 for paper filing. Right now, it went up to $760 for a paper filing. We prefer to file on paper because we can have a better control of the case, and we can actually have a scan of the case, nothing gets cut off, and we are better prepared to go to an interview with the USCIS having this complete file, a copy of the file that went out via mail. So when you complete the form N400 and attach to the form like all the documents that should be attached, like a copy of the passport, copy of your green card, front and back sides, and some other additional documents depending on your specific case, you may go ahead and send the form and documents to the USCIS. Make sure the filing address you are using is correct. The filing addresses, just like the edition of the form, change from time to time, and you need to double check on them on the USCIS's website. And there are different addresses for different states. So let's say you live in the state of Illinois, there will be one address listed for you, and if you live in the state of California, there may be a different address listed on the website, a different filing address that you should be using. It's extremely important because filing with a different, incorrect office or filing box may cause delays in the process, or the application may be returned to you for refiling. So once you file the form and the documents to the USCIS will review the application and documents, and then will issue a receipt notice, which will be sent to your mailing address. That's why it's important to mention the correct mailing address and also have your name on the mailbox so that the notice can reach you in a timely basis. After sending the receipt notices, the USCIS would normally schedule you for a biometrics appointment. So that's where you go to a facility. Those are contractors, third-party contractors of the USCIS that would run biometrics for you, take a picture of you, and send it all to the USCIS so they could run background checks. Once the biometrics is submitted, you have to wait until the USCIS schedules an interview and a naturalization test for you. Based on the current processing timelines officially published by the USCIS on their website, the processing timelines indicate that 80% of the cases are being processed within 16 months or so. In our experience in 2024, the USCIS offices in New York, in California, and in Chicago are processing those applications way faster within, I would say, 5 to 7 months. But that may change at any time, and we cannot guarantee that your application will be processed that quickly. The official processing times are still pretty significant, so keep that in mind. When you file your application for a naturalization, the application will be pending with the USCIS, and if you have a valid green card or permission to travel, you can travel outside the US. Just make sure that you still comply with all the requirements, the continuous residency requirement, physical presence, and that you come back for the interview, and that somebody in the US while you're outside of the US is checking your mail and makes sure that you don't miss any important notices. When you are scheduled for the interview, obviously you need to come to this interview with your supporting documents. Take the naturalization test, which involves English language test, reading, writing, and speaking, and a civics exam on your knowledge of the US history and politics. After that, there will be an oath of allegiance if you pass the interview, and that the oath is usually scheduled, I would say, in 3-4 weeks after the interview. Sometimes it's being delayed depending on how many people the USCIS wants to gather at that oath ceremony. It can be a pretty small number of people, or it can be a stadium of people where hundreds of people go to get naturalized at the same time. And at the end of this process, you become a US citizen, hopefully. All right, so that's the process. Case filing timeline is outlined on this slide. So to prepare the Form N-400, we obviously will need all the documents required and all the information. So it depends on how fast you can produce your documents or your information. And then you can submit the Form N-400 pretty quickly with the mailing service. It can be delivered the next day. The biometrics appointment usually takes a month or two to be scheduled from the date of the filing of the form. The interview and testing, like I said, normally would take 16 months according to the processing timelines that the USCIS publishes on its website. But based on our most recent experience, it takes anywhere from 5 to 7 months or sometimes 12 months. Some applications are being delayed and they may be taking longer. So just keep that in mind. The USCIS issues its decision on Form N-400 sometimes, at the time of the interview, and sometimes it takes a couple of weeks. Sometimes it may take 120 days or even longer. So it all depends on the case that you have in place and on the potential red flags in the case. The interview is obviously one of the most stressful steps in this entire process. So if you were scheduled for the interview, then make sure you get prepared for it. Go through all the questions, the entire application that you filed, memorize the most important dates. Make sure you understand every security question and the meaning of all the words in those questions. If you need help and you're doing this whole process by yourself, then good news for you. The USCIS has an amazing website and it has Citizenship Resource Center on its website. So if you go to the uscis.gov, you can find a lot of resources. You can find resources to prepare yourself for the interview, resources to prepare yourself for the civics exam test in different languages. There are audio tests, there's a written test, there's even an application on your cell phone that you can download and use to prepare yourself for the interview, and there are a lot of other resources published on the website. So the civics exam questions, that is something that may change at any given time. So right now, the number of questions is 100. Previously, we had 200 questions on the civics exam test. Right now, it's 100 questions, which is pretty nice. You will need to go through all the questions, but at the time of the interview, you must get 6 questions out of 10 correct to pass. And if you answer all 6 correctly, then the interviewer will say that you passed the exam. If you answered 5 questions correctly, then made a mistake on question number 6, then an additional question will be asked for you to answer up until 10 questions are asked of you, and the USCIS officer will decide if you passed. If you did not pass the civics exam test, then you will have another chance to come to the USCIS at a different time and hopefully prepare yourself better for the test and pass it. There are some questions on this test that change, the answers to which change from time to time. So senators and representatives sometimes change. As we've seen lately, the Speaker of the House was replaced or changed like several times. That may be the case in the future. So just keep in mind that you need to be up to date with the senators and the names of the senators and the names of the representatives when you actually go to the interview. The answers to the questions obviously will be updated. If you were scheduled for the oath ceremony, what happens at the oath ceremony? So the oath ceremony is the very last step in the process, and this is something that does not require the presence of an attorney. So you go to the oath ceremony yourself, bring your green card, bring your employment authorization documents that were ever issued to you, any travel documents that were issued to you by the USCIS, and you will exchange those for a certificate of naturalization, which is a one-page document that will have your photograph, your name, your date of birth. So that's what you get at the end of the oath ceremony. And before we get to the questions, I also wanted to touch upon the good moral character requirement for a naturalization. So this is a requirement that I mentioned previously. A person who applies for naturalization has to establish that he or she was a person of good moral character and is a person of good moral character and has been such for the review period. So if you're filing based on 5 years, the review period is 5 years. If you're filing based on 3 years of being a lawful permanent resident, then the review period is 3 years. And you have to prove that you've been a person of good moral character during this whole time. There is no exact definition of a good moral character, of a person of a good moral character. So there are certain things that the USCIS would consider in making a decision as to whether you are a person of good moral character. So first of all, they will take a look at your tax returns and see if you file taxes, especially federal tax returns. If you owe any child support, then that's not good, and you have to fix that. If you have any red flags related to any kind of criminal arrests, convictions, even if it's a misdemeanor, depending on the type of the misdemeanor and an offense that you have in your history, the USCIS may consider that a red flag. So just keep in mind, if you have any arrests in the past, if you have any convictions, here we can talk about one of the most, commonly committed offenses is a DUI offense. That's a pretty serious offense. Please talk to your immigration attorney. You may also talk to your criminal attorney and the immigration attorney at the same time if you have a pending case. Generally, when you have a pending case, the USCIS will ask for the documents that would, provide a disposition on the case. They would need to see how the case was resolved before they actually issue a decision on the case. The USCIS's stance on criminal ground of inadmissibility is pretty strict, and they are very conservative in the way they look at certain offenses and grounds of inadmissibility or deportability related to those offenses, but especially they are very conservative in terms of what goes into the good moral character requirement. There is a whole section in the Immigration and Nationality Act that talks about certain things that can be considered, those that would signal that a person is not a person of good moral character. So please keep in mind that this requirement is pretty serious, just like every other requirement. And if you have any offense in your, history, any conviction, any arrest, any citation, then make sure you talk to an immigration attorney to just make sure that this is not going to cause any problems down the way. Otherwise, if you feel like your application is pretty straightforward, then good luck with your application for naturalization. We need more citizens in the US by the election. So if you have your application pending with the USCIS, then good luck at the interview. And if you have any questions related to the process, please let us know. And remember that every case is different. No matter what, you should absolutely talk to an immigration attorney before you file for naturalization. I hope this webinar was helpful, and good luck in your immigration journey.